Sweet.
Sweet.
Okay. I want to talk about the entire process from start to finish and kind of go into the details for what the clients can expect after they file. Well, when they first talk to us and then after they file, to kind of eliminate the stress of, because there's probably a lot of anxiety attached that prevent people from filing just because they don't know exactly what it's going to look like. And then even after they file, what's the next step, or what are they going to send me, what's going to happen. So from my end, I'll kind of go over what I do with new clients, and then you can take over and we'll just do some back and forth for like the paperwork and everything. So the client will speak to me, and I'm the intake specialist. So I'll basically make sure the client qualifies, ask them about their work history and their income and their resources and their disabilities and their medical info, just to figure out if they qualify. If they do qualify, then I do the intake, which is about 30 minutes of me getting everything I need to file the case. After we get everything to file the case, I send them our information. I send the client our information. We file it online either the same or next day. And then I guess we can just pick it up from there. So now we've actually filed the case. The claim is pending with Social Security. What's the first thing that the client gets from Social Security after that?
The first thing they get is what they call the attestation. So, do you attest that you've applied for disability and disability consulting is handling your case? Um, that's usually just, they can sign it or they can just attest it over the phone. Yeah, there are reps, and I did file a claim, and yeah, we're going. After that, the kind of confusing thing about Social Security disability, it's a federal program. It's, if you have a case in Alaska and you have a case in Florida, you have a case in Maine and you have a case in California, they're all processed the same because it's a federal program. However, for the initial filing and the initial case and the recon case, they go to a state agency, and that kind of confuses people. I thought it was federal. Why is it
Right.
going to a state agency? Well, the state agency handles the lower level initial and reconsideration cases. What the claimant can expect from that component of Social Security, they usually call them the DDS, Disability Determination Section. Every state has a kind of a slight different title, but it's the Disability Determination Section. They do make decisions. They have doctors on staff who assess a file and say, well, the medical records show that this person could do light work and that they're mentally moderate in, the 4 work domains, and they could do this and this and this. But what a claimant can expect is lots of paperwork. They're going to get forms to fill out. If they allege pain, they're going to get a pain questionnaire. Where's your pain located? What do you take for it? Do you take it as prescribed? Do you do any other kinds of things for pain relief, hot soaks, injections, creams, anything like that? If you have fatigue, they're going to send you a fatigue questionnaire. Do you wake up tired? Do you have to take naps? If you've alleged a mental health disorder, depression, anxiety, PTSD, anything like that, they're going to send you what they call the ADL form. And ADL stands for Activities of Daily Living. That's a pretty detailed form. I think it's 8 to 10 pages. And it asks about, are you able to cook, clean, shop, drive, take care of your pets? Are you able to handle the household finances? Are you able to concentrate? Are you able to stay on task? And then you're going to get the work history form. That is exactly what it sounds like. They want to know for the last 5 years, what have you done? And you're going to describe that job. That form is imperative it's imperative that you complete it as you did the job. A lot of my clients, they get kind of caught up. Yeah, I was a forklift operator. There's no way I can do it now. So I'll list forklift operator, and I don't have to lift anything because I couldn't lift anything now. And it's like, no. If you were a forklift operator and you had to lift some of the bags to put them on the forklift, or you had to adjust things if they fell off, or if you had to use foot controls all the time in a forklift, which you do. Don't describe it that, yeah, it was just an easy job, because, you know, it would have to be easy for me to do it now. The work history form is how you perform the job when you were doing it.
Yeah, it's the history.
That's right.
Yeah.
And we'll take care of why you can't do that job now at a later time in the process. But those are the main forms: work history, activities of daily living, and pain. And sometimes fatigue. I think they have a seizure questionnaire sometimes for seizure disorders. Some states will send you like a headache form, or there's some other forms too. But most of the time, it's just going to be pain, activities of daily living, and the work history form. And that's what you're going to get. They're going to inundate you with that. So when you apply, it's feast or famine too. You're not going to hear anything where you're going to get the call or a form that says, do you attest to this? And you either attest to it or you call them and attest to it. And then it's just like they've dropped off the face of the earth for a while, because now they're sending the case to these DDSs in these state agency DDSs. And in some states, more states than we'd like to admit, the cases are staged, which means, they just put them someplace and they'll get to them when they can get to them. And it's because of staffing, it's because of other things. We're 5 years past COVID now, and COVID is still causing massive problems in getting things done. So you need to expect that. Social Security disability is a hurry up and wait game. Yeah. You're not going to hear something quickly, and you're going to feel like they just forgotten about you, even though they stage the cases, and when it's they're in this kind of a queue, and when it gets to your turn, then they'll start working it, and then you're going to get form after form. What are they doing? Why are they sending me 5 forms? And you're going to get them, and we can help you complete them. We can kind of guide you through them. I don't fill them out because they are for the claimant to fill out, and I'm not that rep. I don't fill out your stuff. I don't put words in your mouth. I don't tell you what to say. I will tell you what not to say, but I don't tell you what to say. But I can help you through there. What they're asking you is, do you care for, your dogs? That's what they're asking. So if you are, go ahead and do that. And also tell them the problems that you have, lifting a 30-pound pound of a bag of dog food. So you'll get that. And that'll carry us to, I guess, your next question. Because, after the initial decision, if it's favorable, Social Security will likely contact you and just get you in pay status.
You're right.
They treat you a lot differently too. Social Security doesn't like hearing me say this, but the way they treat you before they've approved your case is pretty shabby. They don't treat you well. They kind of ignore you. However, when you've been approved, they pay attention to you, and they want to get you in pay status and get all that squared away. For SSI cases, they have to do an exit interview. It's called the PERC interview, which is pre-effectuation payment or something. It's just a phone call where they ask you, do you have resources? Do you have income? You're going to need to set up a bank account, because we don't want to send you a check. We want to direct deposit everything. If it's a SSDI case, they don't do the PERC interview, but they still would like to get a canceled check, a voided check, or get with you and say, hey, what's your bank account number, so we can send you direct deposit. So that's what happens if you win. If you lose, you want to appeal. As I've said in many of these podcasts, the secret to Social Security, to winning Social Security disability, is when they say no, don't take it as a no. Just take it as we haven't convinced them yet. You just keep on going. The secret is you keep appealing. Eventually, your chances of them seeing it your way, they just keep improving every time that you appeal. So if you're denied at the initial level, you appeal it. Then you go to the reconsideration level. It's the same process. And here's another frustrating thing. All of those forms they inundated you with on the
Yeah.
initial level that you filled out, and then you get denied like 4 months later, and then you appeal it, and then it's been like 6 or 8 months between when you filled out all those forms and they send them all to you again.
Yeah.
And guess what? Yeah, you do. You do need to fill them all out again. Social Security has become goofy about denying people because they don't send in forms. Like, when I worked for them, we never did that. If you didn't fill in the form, okay, we'll try our best to decide your case based on what we have. They literally will just deny you, and they will say, you didn't cooperate, you didn't send us information, we can't even make a medical determination, and they deny the case.
Right.
So the reconsideration, it's the same thing. The staff doctors are going to look at it, staff psychologists are going to look at it, they're going to give a rating. And again, if they approve it, same thing. You'll have the perk interview if you're SSI. You won't have the perk interview, but Social Security will still want to know about direct deposit stuff if you're approved. And if you're denied, then you can appeal it again, and you need to. And the next level is a hearing before an administrative law judge. So I'll leave it there because things change at
Yeah.
that level. It's completely different after that.
Yeah. Okay. So I'll jump in a little bit. I want to talk more about the paperwork specifically,
Okay?
especially because it's a lot of paperwork.
Yes, it is.
It's a lot of paperwork, and then especially if the client is dealing with a disability, then it's like, wow, this other thing that I have to deal with. If it's multiple forms, and then if they have to fill it out again several months later. So the pain questionnaire and the fatigue questionnaire, stuff like that, is that only if you actually allege pain and fatigue or migraines or seizures?
Correct. Yeah. If your case
They're not standard. It's only for specific cases.
right. Yeah. They're not going to send you just throw all sorts of forms at you
Okay.
that don't apply. So for like a case where your allegations are all mental, I've got major depression and severe general anxiety, and that's it. They're not going to send you a pain questionnaire. They're not going to send you a fatigue questionnaire or headache questionnaire or anything like that. But they are going to send you the activities of daily living form, and they'll
Right.
send you the work history form.
And the ADL is basically just what do you do all day?
That's right.
You're not working, so what are you doing all day?
That's right, yeah. And those forms are so critical to your case. It kind of sounds Mickey Mouse, they're sending me forms. They want me to check some boxes, and they want me to explain some things in my scratchy handwriting. Yeah, that's exactly what they want you to do. And keep in mind that when if your case goes to the hearings level, those forms are of the same level as sworn testimony. A lot of people don't think that, but
Yeah.
you said that you couldn't feed your dogs, and you said that you had horrible time with concentration, and that you could only pay attention before you lose focus for 15 minutes. And then there's this huge gap between you filled out that form and, let's say, months and months down the road, we get in front of a judge, and the judge says, are you able to take care of your dogs? Yeah, it's hard, but I do it. Oh, okay. What about, concentration? Do you have any difficulties concentrating? Well, if I really, really push myself, I can stay focused on stuff. It's not easy, but I can do it. Well, now he's like, okay, and the form, she said she couldn't even take care of her dog, and now she's saying that she could if she really pushes herself. She said on the form that she couldn't concentrate for more than 15 minutes, and now here in the hearing, and it'll always go, whatever's the worst for you, that's where they're going to go. Yeah, well, she said she could concentrate. She said she could take care of her pets. Well, she didn't back then. And the vice versa is a lot of times what happens also. They say that they can take care of their dogs on the form. They say that they can concentrate. They say that they shop and they drive and they handle household money. They get in a hearing, and all of a sudden they testify that I can't shop, I can't drive, can't take care of my pets. My husband has to handle the finances of the house. And the judge is like, well, back in the form at exhibit blah blah blah, you say this or this or this or this, and it's that horrible dilemma that you are in, where the judge is wondering, were they lying then,
Yeah.
or are they lying now? Because the end result is they're lying. That's
Yeah.
what the judge is like. Okay, they might have been lying then, but maybe they weren't. But they're lying now.
Yeah.
At the end of the day, you're still going to be accused or found to be lying. So you got to make sure that you just tell it like it is.
Yeah, or maybe if you're not even lying and your condition has actually gotten better.
Changed,
I mean,
that's right.
you want to be honest with that, but if the judge sees that your condition's getting better,
Yeah,
then
and that's another reason where, from the initial level all the way to the next time, if you had to appeal it and you're at the recon level, reconsideration level, and you had to fill out the same form, and you're like, God, why do I have to fill out this form? It's for that very reason, because let's say you got a little bit worse, but your activities of daily living are going to be different.
that makes sense.
Let's
Yeah.
say that your pain got worse, or this happens all the time. I was taking over the counter stuff. 8 months later, they send you a pain questionnaire. I'm taking Percocet. My doctor's, I'm not over the counter anymore. My doctor's, makes a big difference.
Yeah,
So
sure.
it makes sense for them to send you that form again. Nobody wants to fill them out because they are time consuming, and they're tedious. I mean, because you're handwriting everything, and then you're literally putting it in the mail.
Mm-hmm.
Sometimes you mail it to us and we'll forward it on, or you can email it to us and we'll forward it on. But like I said, I'm not going to do it. Claimant has to do it, and I'll help them mail it and get it to Social Security, but they have to do it.
I want to be clear on that, because I know a lot of people are going to hear that and they're going to think, if I'm hiring a representative, why am I the one filling out the forms?
Yeah.
And it seems like what you're pretty much saying is, we'll walk you through filling out the forms, but we're not going to put words in your mouth. We're not going to make up answers for you, because that's just not the quality of representation that we try to do.
Exactly. It's not. It's not right.
Is it legal? I mean, are you
No.
even allowed to do that?
No.
Yeah.
No, absolutely not. The representatives get a really bad rap, and the representative community, in many ways, has earned the bad rap that they coach their clients. Hey, when the judge asks you how much you could lift or carry, tell them a gallon of milk. We hear that in hearings all the time. When the judge asks you this, tell him that. You're not supposed to do that. It's not ethical, and I just don't want to do it.
Yeah.
I think the worst thing would be for somebody to be in a hearing and they say something and the judge is like, well, the form you filled out, 12 months ago doesn't say that. Well, my representative said that I needed to tell you this. Okay, well,
That's bad news for the representative.
bad news for the representative. And by the way, you're going to lose your case because the judge can't believe what you're saying. So there's that. But just the sheer ethics of it bothers me. And a lot of my clients do get angry about that. What am I paying you for? Well, it's a contingency fee for one thing.
Yeah,
You haven't paid me anything
Right
yet.
now, nothing. Yeah.
So you're not paying me anything, but what you're paying me for is my expertise. And you need to trust my expertise. And my expertise advice to you is you fill out this form and you put things in your words and you tell the truth and you do the best you possibly can to let whoever's reading this form know why you're disabled.
Mm-hmm.
I can't concentrate for more than 15 minutes. I'm not going to tell you that.
Yeah.
Usually, when I get your case, and I get it from you, the intake specialist, you've already told us that. I can't concentrate for more than 15 minutes at a time. Okay, just write it down.
Yeah.
Don't have me write it down. You can write it down. It's your form. You have to sign it. The only possible exception, and it's happened before, the only possible exception would be if you're simply not able to. You're either, for whatever reason, not able to physically fill out the form, or cognitively you're having a real hard time communicating. In those cases, your significant other could fill out the form, and we have called some of our clients who are poorly educated and they can't write very well. And we actually write at the bottom of the form after we filled it out, all this information taken in phone call on April the 4th, 2025, by Mr. So-and-so and dictate it to me, and then we'll sign our name. But that happens so rarely. There's just, there's really no reason for it. A lot of people, kind of getting off track, but a lot of people expect that when they hire a representative, they just hand everything to them. I never thought that. Even when I was working for disability, before I became a rep, I saw a rep and a client as a partnership. I've got some expertise. I'm going to tell you, the way things have to go. I need to tell you the things that, you better not say to Social Security because it's not true. You definitely need to say these things, even though you don't think they're important. You can only concentrate for 15 minutes. Very important. You need to tell Social Security that. You have difficulties handling household finances. You have difficulties shopping. You have to tell Social Security that.
Yeah.
Trust my expertise. You might not think it's a big deal. It's a huge deal. But I just have always viewed it, and certainly now that I do it, as a partnership. We're in this together. I am going to give you some expertise. And if you're wise, you'll take it because, we win a lot of our cases because we know what Social Security is looking for and what they expect.
Yeah.
Social Security, don't ever think that if they send you something, they don't really care about getting it back. If they send you something, they expect it back. I can tell you why you know that they expect it back. They're sending you an envelope to send it back in. They've already paid for it. Postage paid, just send it, fold it up after you filled it out, put it back in there. They expect it. And again, like I said, they've gotten goofy in recent years that they will deny your case just for not filling out forms. They'll do it. I mean, I see it weekly. Why didn't they fill out their form?
Yeah.
Why didn't you fill out your form? Thought you were going to do it. No,
Yeah.
you didn't.
Yeah. Or they just rush through it because they don't think it's a very big deal.
Yeah.
Yeah.
Or they rush through it, especially like the ADL form.
Yeah.
They rush through it and without talking to us about it, because once again, it's a partnership. I'm going to give you my expertise. Let me tell you what you need to do. You fill out that form and you tell Social Security because they ask these questions, and this is what they give you for the answer. You get that much to give them an answer. Yeah. And it's basically they're asking you what you're able to do. What are your abilities? What are your abilities? What are you able to do? What are you able to do? And I always remind my clients, we're not filing for ability. We're filing for disability. So you go ahead and you go outside the margins when you say, yes, I can feed my dog, but I do it so poorly that sometimes my kids have to come do it because the dog, there's nothing in the dog bowl. I forgot all about it. Okay. That's what a disabled person would say. Mm-hmm. If you just tell them what you do, yeah, it can do it. It's going to go poorly for you. Plus, it's not the truth. We've talked about that before. There's the truth and there's the whole truth.
Very different.
Yeah, the truth, I feed my dogs. What's the whole truth? Feed my dogs some of the time, but not always. Okay. Big difference, especially in disability. Mm-hmm. Just go ahead and take that and put it in a work scenario. You do your job. Okay, what's the whole truth? I do my job about 75% of the time. Okay, you're fired.
Yeah.
You're disabled if you can only do it 75% of the time. That means that 25% of the time you're not able to do your job. Big difference. So that's what we that's definitely what we advise our clients.
Yeah. So these forms are important.
Very important.
Yeah, and we will help a client fill them out in the context of if they're just confused on what Social Security is asking them,
Sure.
or they don't know how to fill it out, they don't know how to send it back, or
Sure.
what if they need to. Maybe they're confused on if they're sending it to us or Social Security. We'll definitely help with that kind of stuff. We're just not going to literally fill out the form for the client.
Exactly. And just going back on your theme of this podcast, so what happens next? The big part I left out is when you first come to us, and after you've done your thing and we filed your application, you're going to get a call from a case manager, a disability consulting case manager, and they're basically going to introduce themselves. There are always two people at Disability Consulting, at least two people, working your case. That is your case manager. Your case is literally assigned to them, and they carry it throughout the whole process. And then there's the representative, me, and we've got other representatives in Disability Consulting. We kind of oversee everything, and we make the argument. Okay, Mr. Smith is disabled because of this law, and this is what the medical records show, and this is why Social Security needs to find them disabled. So, for what happens when the case comes to us, that's what we're doing. What you will rarely know is that in that huge expanse that I told you guys about a second ago, did they forget about me? I haven't heard from Social Security in 6 months. Disability Consulting, your case manager has called Social Security probably once a month, if not once a month, once every 45 days, because that's our policy. They'll usually try to contact you or text you or email you and let you know we're pushing them, but they're not doing anything on your case right now. But that's we, unlike Social Security, we don't stage cases. We want to get them approved, and we want to get them approved as fast as possible, and that means calling Social Security and kind of being the squeaky wheel. And don't ever think that the squeaky wheel doesn't get the grease. The squeaky wheel does get, if we make a nuisance of ourselves enough, eventually they're like, God, I'm so sick of Disability Consulting calling me every 2 weeks on this case. All right, let's get it done. Thank you very much.
Yeah. I always tell clients, that's what I tell clients is, we, as a representative firm, we go as fast as we possibly can, but we're kind of at the mercy of, well, not kind of, we are at the mercy of Social Security.
100%.
But yeah, sometimes I'll speak to a client and I'll do an intake in 30 minutes. And then 30 minutes after that, I'll see like the notification that the file or the claim has been filed. So it's like within 1 hour of talking to this client, their claim is already online and we're already working on it.
We got good peeps, and we do work quickly. I've never found there's really any good reason to sit on my hands as far as waiting for a case, and it just kind of bugs me. I try as best I can to put myself in my client's shoes. When they call and they're angry, why is this taking so long? I get it. I am not going to. Our case managers, our receptionists, our reps. We're just not going to lash out at you, even if you've lashed out at us, because I'd be the same way. I'd be absolutely incensed that it's taking as long as it takes, and it does.
It's ridiculous.
Yeah, it takes a horribly long time, and absolutely, if you call up and you're really angry and you vent, and we seem to be bearing the brunt of that, unless you're like you get abusive. Yeah. I get it, and you're just not gonna get any blowback from our employees, because we get it. I mean, if we were in your shoes, that's exactly how we would be. What do you mean it's taking 8 months to do this? How long does it take to order medical records and read them? It don't take 8 months. And of course they'll say there's staffing shortages, and there's always a reason.
Yeah. Okay. So this is not directly related to the process itself, but it kind of is. We'll talk about paperwork in MSS form. So that kind of goes along with, you file the claim, we get it online, Social Security, you've attested to your case, which means you are confirming that you really do want us to represent you. And then they've sent the client the ADL and maybe a pain questionnaire, stuff like that.
Right.
And then we will usually send the client an MSS, which is a medical source statement. I don't actually know when we send that, so you can fill me in there.
Yeah, I mean, it's different for several different cases. Unfortunately, for all you folks out there who are 49 and younger, it is our policy that we want a medical source statement from your provider, at least one, and it's got to be supportive. Not only are they giving us an opinion that you are disabled, that you're disabled, it's got to read like, yeah, they couldn't do this 8 hours a day, or they couldn't stand or walk or lift or carry or concentrate or stay on task in the amount that a job would require. 50 and over, we're a little bit more lax on it because the law changes. I mean, it just does. We've talked about the grid rules before. Once you hit 50, I literally don't have to prove that you can't do anything. I only have to prove that you're limited to either a sit-down job, or the older you get, that you just can't do what you used to do, your past jobs. Another reason why it's so important to fill out that work history form and fill it out accurately. This is what I did. This is how I did it. And it was this demanding. And so we can use that, at a later time. But yes, the medical source statement, look at it like this. The judge is a lawyer. The lower levels they're not lawyers at all. They're just lay people. I think most states require that they have a college degree to work as a disability claims examiner. I did. And but they're not a doctor. They're not, they don't have any medical expertise. A judge has no medical expertise.
Yeah.
And so the value of a medical source statement, which is just an opinion that your provider gives about your limitations. Think about that. If we have that in the case file, here's, the medical records stand on their own. But then you supplement that with a medical source statement. You have my medical records, but let me tell you what else is wrong with Mr. Smith. And Mr. Smith, there's no way that he could be on his feet for more than 10 minutes at a time. There's no way that he could lift more than 5 pounds. There's no way that he could stoop, crawl, crouch, all sorts of other things. And they write all these limitations in, and then they sign their name. And it's like, who are you going to argue with that? Now the judge can argue with that, and the judge can say, I don't believe their opinion is supported. And the lower levels can say, no, I'm not going to go with that. Those are almost always won when I appeal them.
Yeah.
Almost always. Unless it's so out of so unsupported by the record. It doesn't have to be exactly supported. It has to be supported. That's the law. And is it supported? So if, so-and-so's, this doctor's been seeing Mr. Smith for 20 years, gonna argue with that doctor about what Mr. Smith is capable of doing. You can do it if you want to, but let me tell you what's gonna happen. Either on appeal, whoever's looking at your decision, when they're not laughing, they'll be rolling their eyes. And the federal courts will probably be laughing, rolling their eyes, and then they'll write something snarky when they remand the case back to you to redo it.
Yeah.
Dr. So-and-so is a doctor. He's in good standing. How in the world
he knows what he's talking about.
How in the world you could come up with your own, medical assessment when you possess no medical credentials whatsoever, and you rejected his. It's just that, like I said, we're going to win those on appeal.
Right.
So it's very important.
And so in practice, what a medical source statement actually is, we mail that. Do we always mail it to the client?
Yep.
Is it by mail? So
Yep.
we mail it to the client takes it to their doctor's visit.
Right.
And then they basically say, hey, I'm applying for disability. My representative gave me this form, and then the doctor fills it out.
Yeah.
And then they mail it back to us?
Yep. Yeah, we definitely want the doctor to mail it directly to us.
Okay.
The reason we send it to the client, because we found this out, and this is just every representative I've ever spoken with, all of my competitors, colleagues across the nation, they all have this problem. You send it, and you never hear anything, and you call the doctor's office, and you say, hey, we sent you a form on your patient so-and-so. Oh, well, we never got that. Okay, well, I'll send it again. We never got that. Okay, are you by the fax machine? Because I'm sending it right now. Well, we're busy, and go ahead and send it, and I'll be looking for it. And you call back a couple of days later. We never got that. And what happens is, they're running an office, And the last thing they care about is some, 2-page form that comes over the fax machine that they have to send to, or they have to deliver to the doctor, have to pull so-and-so's chart and stuff like that. So what we do is we send it to the client and say, hey, next time you go to your doctor, ask them if they'll fill this out. Don't tell them what they need to fill out. Everything they need, all the instructions, I've given them the instructions. I've given them Social Security's laws. All they got to do is fill it out. It's very easy for them to do. It takes maybe 5 or 10 minutes if they know their patient.
Mm-hmm.
That's the thing. And of course, we're counting on them knowing their patient. Don't take this to a doctor you've never seen before. It's useless. We want you to take this to somebody who knows your limitations.
Right.
So that's why we do it, why we send it to the client. It won't get put in the trash can, which is where they all end up if we just mail them or fax them to the doctor's office. But we do want the doctor's office to mail it or fax it back directly to us, because we don't want the client. First of all, you probably don't want to know what your doctor thinks about your limitations. I mean, it's true. They're there to treat you, not basically say, yeah, they've really got this and it's a horrible problem,
Right. Okay. So assuming the client gets the ADL figured out, or filled out rather, and then they send it to Social Security, and then they get the medical source statement, maybe they're denied a couple of times and we're at the hearing level.
Yeah.
After the hearing level, if they are denied, is there any additional paperwork that the client fills out? Because we appeal the judge's denial to the appeals council. That's the next stage of the disability process.
Right.
Does the client, from that point on, do they actually fill out any other paperwork, or is that really just a waiting game at that point?
Yeah, there are, we've talked about there's 5 levels, but really in Social Security, there's only 4.
Mm-hmm.
So there's the initial, the reconsideration, the hearing, the appeals council. Once the appeals council makes a decision, if they don't remand it and they affirm the judge's decision, basically, yeah, the judge was right and we're done. This is the final decision of Social Security. That's the way it reads. If you want to appeal it further, you go to federal district court. But, my long answer to your short question is, yeah, there's no paperwork. The appeals council appeal, just a brief that I write,
Yeah.
and I send it to them. They, 21 years, they've never sent my client, hey, if we had just one more form for you, that you could fill out, maybe we could, make a better decision. That doesn't happen. They'll make the decision, and then they'll send us, usually it's a remand, which means that they just send it back to the judge. You got to fix these things, and or they'll affirm it, rubber stamp it, and say, we think the judge was right, and we're done with it.
Right.
And then the federal district court, if we shop the case around, there are some forms that the claimant has to fill out, but they're not Social Security forms at that point. They're just forms for the attorney who's handling the federal court case, and they're all pretty easy and self-explanatory.
Mm-hmm. Okay. And then if the appeals council level is denied, and we go to the federal case, we have attorneys that work on that, so we do appeal it to the federal level. We would then file a new Social Security case while the federal case is pending, right?
Yeah.
And
9 times out of 10,
Mhm.
not all the time. Let's say that it's, we've talked about the date last insured.
Mhm.
Let's say that you're Title II only, SSDI only, and your date last insured was in 2024. We've been working on your case since 2022, so
Right.
we had that window, and then the case just wends its way through. We hand it off to federal court because Social Security has said, at the appeals council has said, nope, we're done. We think the judge was right, and we're going to affirm his denial. And so we're shopping it to federal court, and one of our attorneys says, yeah, I think we can work with this, so we might be able to get it remanded. We would not at that point tell our client to file a new claim.
because they don't qualify
They don't
if they start
qualify
a new
anymore.
case.
Yeah,
That makes sense.
that window has already closed. So those cases, that's the bad news about those cases is, you can't. There's really nothing to file. The good news about them is if the federal court, if the attorneys take it to federal court, they're really high priority cases because they realize this is it. This, you know, we do a really hard sell on our attorney partners on these cases. Hey, if you don't take this case, if you don't think that this case has merit, you need to realize that he or she, they've got nowhere else to go. This is it. They had that window. Their date last insured has expired, so they can't make a new application. They're done, and so we kind of put a hard sell on them, on these attorneys. Listen, really, really think hard about whether you want to say no to this person, because you should say yes.
Right. And then if they do take it to federal and the client is eligible to start a new case, and assuming that we do that,
Right.
unfortunately, we do have to fill out all of the same paperwork and go through the same system, right?
That is true.
But then if the federal case is remanded, then it'll just go back to the hearing level. We'll have a second hearing or another hearing,
Yeah.
and then that protective filing date is still valid.
Yeah, and what they call them either absorbed cases, or escalated cases.
That's
But,
kind of how I thought of them, but I didn't know they actually call them
That's what
that.
happens. So it's like
They basically merge.
If a case comes back on remand, and there's like a reconsideration case that's pending, they're done with the reconsideration case. They'll just merge it all back.
Right. Yeah. Okay.
And that's the way they should do it. I mean, that's, that makes it nice and tidy.
All right. Well, I think the federal case that's the end of the road. Oh, well, so we'll talk about this. If they're approved for benefits, what can they expect immediately after that? Like if they get a approval letter, how long does it take to get their money? Are there any forms to fill out after that? What does the client expect after they're approved?
Great question. It's the happiest thing I get
It's
to
the best
talk
question.
about.
Yeah. After you win.
So the first thing is the notice of decision. You won. Like there's 3 decisions that can come to you: either fully favorable, which is you won, and the judge or whoever is going all the way back to when you said you became disabled. Fully favorable. Everything we wanted to get, we got. Then there's partially favorable. They find you disabled. However, you said you were disabled when you were 53, and they find that you're disabled at 55. So you're not going to get as much back pay. We're not going to get as much as a fee. You can appeal that, but it's still good news that they have found you're disabled. And then there's the worst one, unfavorable. We don't find you disabled, and that's where all these appeals come in. So yes, that's the first one, the notice of decision. The big one is the notice of award. And the notice of award tells you all the things that I really can't tell you other than you won when the case is won. But the notice of award will tell you how much your monthly benefit's going to be, how much your back pay is going to be, how much they've approved for my fee, because Social Security has to approve my fee. I can't just charge anything that I want. They have to actually approve my fee. When your medical coverage is going to start, and basically, it's a pretty long letter, but it's great. I love those letters, because they tell you everything. Because that's the big thing, how much am I going to get? How much is my back pay? How much do I owe you? And when does my medical coverage start? And the time frame we're looking at now, from a hearing to getting the decision letter, is 30 to 45 days, which is about half of what it was 5 years ago. So they've made great progress on that. And then, if you are approved, the notice of award, that's pretty quick. It comes, anywhere from 3 to 5 weeks. It's pretty quick. And of course, after the notice of award, and you get paid, which is a lot of times, if you've done direct deposit with Social Security, many, many times you will, if you check your bank, notice this big chunk of money in your bank account. And a few days later, you'll get a notice of award from Social Security that, we're going to send you, when they've already sent it. And, people call me up all the time. And again, it's a call I love getting. There's like $25,000 in my bank from Social Security. Did we win? Yes.
Yep.
Yes,
Sounds like it.
Yes, we won. And that's, you'll get the letter that tells you that you're going to be getting $25,000, which they've already sent. But again, a few weeks, 3 to 5 weeks after the notice of decision.
Right.
So
will the client have already given Social Security their banking information at that time?
most of the time, that's.
Yeah.
a lot of times they do it right out of the gate. Social Security is one of the things, attestation that they want. If not, on an SSI case, they'll get it at the interview, and they'll really put a hard press on the claimant too. So you need to expect that. They want to give you direct deposit.
Yeah.
They don't want to send you checks. And in fact, I don't even know if they're allowed to send you checks anymore. So you have to get a bank account.
Nice.
Not a bad thing.
Okay. Well, I think that's everything I wanted to talk about. Are there any other tips or tricks that you want to bring up as far as the paperwork goes? I really want to talk about the paperwork more than anything else.
Yeah, I mean, no tricks, but the tip is we talk about the process so much. It's part of the process, and it's really easy to just kind of, whatever, because it's, when they're sending envelopes that are this thick, because they're sending you an 8 to 10 page ADL form, a 4-page pain questionnaire, they're sending it, just getting inundated by this stuff. Just recognize that it's the best way for you to exchange information. And that's what you're wanting to do. You're wanting to give Social Security the information they need to make the decision that you want them to make. Talking about your pain, talking about pain medications, talking about side effects, talking about, I take it, but my pain level is still at a 7 or an 8. Okay, if your pain level's at a 7 or 8, you can't work. Your concentration would be garbage. There's no way that you could, stay on task. Fill out an ADL. I used to be able to do this, and now I can't even do that. I used to be able to do laundry, and it's my 13-year-old daughter has to do laundry now. That's what a disabled person would say. Those are the things that you would expect to see if you're communicating what's going on with you. And the way you do it is with these forms. There's no way in the world that Social Security is going to call you up and just interview you about all the things you got going on with you. They're just not going to do that. They're going to send you a form. You're going to fill it out, and then they're going to make that part of your case record. And they're either going to look at it and give it credence, or they're going to look at it and roll their eyes and say, well, I still think that they could, be a ditch digger or some garbage like that, which is where we come in and say, that's garbage, can't do that. But that's, like I said, no tricks, but tips. Yeah, it's the process, and it's like anything else. If you want to do things right, sometimes it takes a little more time. Well, usually it takes more time if you're going to do something right. And getting your information to Social Security correctly and thoroughly is imperative to your case. And the way you do that, unfortunately, whether you like it or not, the way you do that is with these forms. So that's the tip. Go ahead and cooperate with Social Security. They're going to pay for the return postage. You don't even have to buy a stamp. You just have to fill the thing out. They give you 10 days to do it, and that's 10 days from the day you get it. So they really give you like 14 days to do it. That's long enough. Spend a couple hours, get them all done. Doesn't have to be in your handwriting. If you want your spouse to do it, or one of your teenage or adult kids to do it. Hey, Dad, they're asking, how long can you concentrate? For about 15 minutes. And at the end of it all, turn it on the back page where you have the signature, and you sign it, and that's cool. They might say, the handwriting's a little bit different. Yeah, my daughter did it. Cool, that's fine.
Right.
You signed it, So there's several ways that you can lessen the burden of doing that, but it has to be done. It's absolutely imperative to winning your case.
Yeah, you're going to have to fill out some paperwork, and it's going to be a longer process. And those are two things that you really can't change with the Social Security process.
Exactly.
Good.
Yeah.
All right. Well, good insight. I think
All right.
that's a wrap.
That's a wrap.